All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon, everyone, in and outside the courtroom. Mr. Court Officer, can you please call the case?
Good afternoon, Your Honors. This is file number KSCBC 2020-04, the Specialist Prosecutor versus Pjetër Shala.
Thank you, Mr. Court Officer. Now I will kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Good afternoon, Your Honor. Today, for the prosecution, are appearing Bernard Kuchnik, Associate Legal Officer, Marlene Yaya, Disclosure Officer, Daniel Mezei, our Case Manager, and Moira van der Pol, our Legal Intern, plus myself, Filippo De Minicis, Associate Prosecutor.
Thank you, Mr. Prosecutor. Now I turn to the defense. Mr. Gillissen, please.
Yes, good afternoon, Mr. President. I'm Mr. Jean-Louis Gillissen from the Bar of Liège. I'm assisted by Mr. Awini, you know him perfectly well, and a brand new one, Miss Maria Teresa Kukai. She is coming from Albania. And we have Mr. Shala, who is with us by video link from the detention center. Thank you.
Thank you, Mr. Gillissen. And I note that Mr. Shala has waived his right to be present in the courtroom, but he's attending via video conference. Let me turn to the registry.
Thank you. Good afternoon, Your Honor. Jonas Nilsson, Judicial Services Division Registry.
Thank you, Mr. Nilsson. And for the record, I'm Nicholas Guillou, pretrial judge for this case. On 20 December, I scheduled the fifth status conference in this case. My goal today, as usual, is to review the status of the case and to organize exchanges between the parties to ensure an expeditious preparation for trial. In particular, I wish to discuss disclosure of evidentiary material, translations, the status of the specialist prosecutor's investigations, the status of the defense investigations, the points of agreement on matters of law and facts, detention, and finally, any other issues the parties may wish to raise. I thank the SPO and the defense for their submissions ahead of the status conference. And as usual, I will invite the parties to present their views in a concise fashion about each item of the agenda, which I will address individually. So let us start with the first topic on our agenda, which is disclosure. I will give the floor to the parties on the disclosure of each category of evidentiary material separately, as we did last time. The Rule 1023 material first, which is the material relevant to the case as listed by the SPO. The Rule 103 material, which is exculpatory material. And the Rule 107 material, which is protected material for which the consent of the provider is requested. But before addressing the disclosure of these material, I noticed that the SPO disclosed Rule 1021B material last night, even though it had confirmed that it had completed its disclosure of such material at the previous status conference. So, Mr. Prosecutor, could you please provide more detail on this recent disclosure package, please? Thank you.
Will do, Your Honor. So it's true that the last status conference we announced that we had finished our Rule 1021 disclosure, and perhaps we were imprecise in the sense that there were 3 items outstanding that Your Honor had authorized for deferred disclosure in decision F72 in this case, pending a protective measure decision in case 6. So these are the documents that were the subject of that decision, and that further to the issuance of that decision, we then disclosed with the same protective measures in this case. And these were 3 of the 6 documents disclosed yesterday. Other 3, 2 were the English and Albanian transcription of a video which had already been disclosed, Your Honor, as part of Package 11 on 31 July 2021. And the other one is the translation of the relevant portion of SITF 000-20142, which was disclosed in Package 12 on 1st September.
And were these additional disclosures made at the request of the defense for the translation and the transcript, as you mentioned, or did you do it?
We did it because they're part of our Rule 102, 1B obligations, Your Honor, and so we did it autonomously, I believe.
And there is no specific reason why it has been done now and not a couple of months ago?
Your Honor, the specific reason in that regard, I might need to get back to you on that one, Your Honor. At the moment, I don't have a precise answer.
And a follow-up question, can you now confirm that there is no more Rule 102.1b material left to be disclosed?
Well, Your Honor, there are 4 items which were also subject to the same decision, which in the case, in a separate Case 6 decision, were in fact authorized to be withheld. So we have not disclosed those, and we will be seeking authorization from Your Honor to withhold disclosure of these 4 items until the reasons exist behind that protective measure.
And apart from these 4 items, no more items to disclose, correct?
Your Honor, I think, yes, I can positively confirm that.
Thank you. This is noted.
Thank you, Your Honor.
Does the defense want to mention something just on the Rule 102.1b material, please? Mr. Ayuni.
Good afternoon, Your Honor, and best wishes for the new year to everyone. Mr. Gillison will make submissions on the disclosure in general, but just on this specific point, maybe I can be of assistance to bring some history. During the first and between the first and second stage conferences, and Your Honor will remember, we have made a request to the SPO to disclose audio-video material of witness interviews. And we provided justifications. So far we reached 2 witnesses for which we requested this material. This is 102.1b. Yesterday, in the evening, we received correspondence from the SPO explaining that they are making an attempt by improving the transcription of some videos to, let's say, overcome some of the difficulties and the justifications that we have put to them to request the audio-video. So these may or may not be, because we didn't have a fair chance to look at the disclosure itself. Might be 2 of the 3 items our colleagues from the SPO are mentioning. And these are also, it's important for us to put on the record, because we maintain our request to receive those audio-video materials. We believe it is very important to receive them in the original language, because gestures and some elements that cannot be transcribed are involved in those materials. So we expect to receive more 102.1b material of items that we received in and to put it generally, in unsatisfactory manner. So just to put that on the record, we might have to come back to these issues, because we will make new requests for other witnesses for audio-video, and also if things are not resolved with the 2 that we already requested, then we might have to come back to you. But there should be, if the SPO accedes to our request, some more items disclosed that are part of what has been disclosed before. Thank you, Your Honor.
Thank you, Mr. Ayuni. Mr. Prosecutor, do you want to add anything on this, these potential requests?
Yes, just to clarify that the items that we disclosed yesterday are not related to the AV recordings that the defense had requested. We, at this point, I don't have anything else to add. There have been inter partes communication with the defense on that issue. We hope to continue these communications, and that's all I have on this, Your Honor.
Thank you, Mr. Prosecutor. Then I invite the parties to continue their inter partes discussion on this topic and to seize me in case of litigation on this matter, and to seize me as earlier as possible so that this can be resolved. So I hope that before the next status conference, this will be definitely over. So either through a discussion between the parties or seizing myself if needed. Mr. Prosecutor, you want to add something?
Yes, Your Honor. I want also to add that when I said that we finished our Rule 102 disclosure, I mean in terms of any new materials that we're not going to disclose any new materials that we're done with. However, for instance, the defense requested a number of translations for translations concerning Rule 102 one material, and we will be providing these translations to the defense. We've already instructed our language unit to work on these translations. So when I said no more Rule 102 disclosure, I meant there are no documents that the defense does not have access to that would be disclosed, but maybe translations or video recording that correspond to transcript that have already been disclosed.
This is noted, Mr. Prosecutor. Let me continue our agenda today with the disclosure of evidentiary material relevant to the case, which is the Rule 102.3 material. The SPO indicated in its submissions that it has not challenged the materiality of any of the requested items from the supplemented Rule 102.3 notice. The SPO also confirmed that all requested materials from the supplemented Rule 102.3 notice, which did not require redactions or required only standard redactions, were already disclosed. In its written submissions, the defense, however, noted its concern about the adequacy and sufficiency of the description of items in the prosecution's possession as listed in the prosecution's Rule 102.3 notice. The defense also indicated that it would invite the prosecution to review its supplemental Rule 102.3 notice and provide additional information about the items listed therein. I note that the SPO's supplemental Rule 102.3 notice was distributed this morning, and I shall say a new supplemental notice. I take note of the fact that the additional items included in the notice could not be previously listed due to Rule 107 restrictions, and that, therefore, the SPO was required to file a supplemental notice. However, at the third status conference, I specifically indicated to the SPO that it should seek leave before filing a supplemental Rule 102.3 notice. Thus, I again remind the SPO to, if necessary, seek leave to supplement its notice in the future. I invite the parties to give an update on the disclosure of these category of materials, notably on the number of items that remain to be disclosed by the SPO and the anticipated timeline for completing the disclosure, on the need to possibly further supplement the Rule 102.3 notice in the future, and on the inter partes discussions and whether the parties anticipate resolving the issues identified by the defense in its submissions. Mr. Prosecutor.
Thank you, Your Honor. Your Honor, on 5 and 25 November 2021, we have disclosed 837 Rule 102.3 documents that were part of defense requests that amounted to 1,071 documents. We have at the same time informed the defense with the table for the reason reasons for the non-disclosure of some of the items that they had requested. None of them concerned the materiality of these items. We consider that we have disclosed all the requested items to the defense, with the exception of those that we haven't, and explained to them why. So we're of the view that there are no outstanding items at the moment pending. Now, with regard to the sufficiency and adequacy of the descriptions of these items in the Rule 1023, Your Honor, I note that the new and updated Rule 1023 list contains updated and improved and more precise descriptions of these items, which, however, these updated descriptions, for the record, were notified inter partes to the defense on 22nd of October 2021. So these descriptions have been available to them since that date, and we have now formally put them on the record with the filing of the revised Rule 1023 list. With regard to inter partes communication that continue, not only with respect to the disclosure of 1023 items, but with disclosure more generally. On the 23rd of December, we received a helpful email from the defense summing up all the issues they considered outstanding. We have yesterday responded to that email, putting on the record our position on these outstanding matters. Hopefully that will be and can be the starting point of future discussions with the defense on these matters, Your Honor.
Thank you, Mr. Prosecutor. Mr. Gillissen, you have the floor.
Thank you, Your Honor. Thank you. We confirm we don't have any knowledge of the SPO challenge to the materiality of intents we have selected from the notice. We had a multiple discussion with the SPO on this issue. First of all, we discussed a few items with the SPO, which gave us further explanation of the content of certain items. And this resulted in a disclosure of this item partially or completely, without any challenge to the materiality being made. Concerning the second indication, there was disclosure of the items selected without any material challenge or discussion. And third, we had a discussion on materiality with the SPO regarding a few items which result in no agreement. And now, I can say we maintain our indication and selection for these items because we believe that the items in question were evidently relevant to us. This solution didn't result in a challenge to materiality from the SPO, and we thank them for the reasonable decision not to challenge the materiality of evidently, and clearly relevant material.
Thank you, Mr. Gillissen. Mr. Prosecutor, do you want to?
No, Your Honor. Thank you. Nothing further.
Mr. Ayuni, you want to add something? Mr. Gillissen, your microphone is on.
Yes, of course.
Sorry, Your Honor. Just to put on the record one discrete element, as part of our indications in the notice, we have specified there is no issue at stake right now, but just to put it on the record in case further on we come to a problem related to that. In our indications, in several occasions, we have made indications that are of the type of the selection of an entire case file. When there is a reference number to a proceeding from a different country or things of the sort, that we requested, since the descriptions are not exhaustive and not sometimes helpful, that we receive the entire documents related to a case file that we believe is relevant to us. The SPO colleagues have indicated that they would try to do it as much as possible, and that at some times they receive themselves certain elements of case files in piecemeal fashion. but just to put it on the record in case there is an element that we discover later on that is missing that was part of a case file or a reference number or an investigation that we requested as a whole and as a unit. That's all. Thank you.
This is noted. Thank you, Mr. Ayuni. Mr. Prosecutor, do you want to specifically add something on what has just been mentioned?
No, Your Honor, I don't think we will add anything on that point. Just something else on the Rule 102.3 disclosure. There are certain items that we haven't disclosed yet because they're subject to protective measure requests that Your Honor is, they're pending before Your Honor. So.
Absolutely. So I don't see any requests for the floor, so we will now move to Rule 102.3 material. In its written submissions, the SPO indicated that it has made further progress and reviewed 30% of the outstanding documents mentioned in the supplemented Rule 102.3 notice for potentially exculpatory content. The SPO indicated that it plans to continue proceedings with comparable pace and strive towards disclosing any remaining document falling under Rule 103 as soon as possible. Before I give the floor to the prosecutor, I would like to remind the SPO of its obligation to disclose exculpatory evidence immediately as soon as it is in its custody, control, or actual knowledge, and only justifiable reasons, such as the need for redactions, may prevent immediate disclosure. This means that the disclosure of exculpatory material should not be done at the end of the pretrial phase. I am a bit surprised, to be honest, that the SPO indicates that it has only reviewed 30% of the Rule 102.3 material, and I invite the SPO to explain why it has not already finalized the disclosure of Rule 103 material, which is fundamental for the defense and fundamental for the defense investigations, and thus for the timeline of the pretrial phase. I further invite the SPO to clarify whether the exculpatory material disclosed last night covers the anticipated disclosure referred to in its submissions. And I would also like to know more generally whether any request for protective measures for any exculpatory material is imminent. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. In fact, since the filing of the submissions, we have made more progress on the review of potential exculpatory materials, and I believe that we're now at about a 50% rate of that amount of materials. The documents that we have disclosed last night, there were some additional documents that we have found between the filing of the submissions and yesterday. A very small number, Your Honor, compared to the total number of the documents that we have reviewed. We'll continue to do so at as fast a pace as possible, Your Honor, but we don't believe that it will take long, and we are somewhat in this regard by the fact that we have identified a very small number of documents in the review so far, but we'll continue to do so at our fastest pace, Your Honor, and disclose any outstanding document as soon as possible.
You can imagine that when you tell me that you believe that it's not going to be very long, and you tell me about the fastest pace, I'm going to ask you about a timeline. So instead of as fast as possible or to the best of our possibilities, I'd like to know when you will be done with this review. If I do some math, you had reviewed 30% before your submissions earlier this week. So it means that in 3 days you managed to do 20%. So if I apply this mathematical formula to do the 50%, I will probably have to multiply this by 2.5, 3 multiplied by 2.5. So we can do the math. It should be done in the next 2 weeks.
Your Honor, there's documents vary in size. There's some documents who may be 100 pages, a few hundred pages, and some others just a couple of them. So, yeah, that's why the numbers sometimes may not give the full picture in terms of percentage. But we will, to our best, and I'm confident we'll be able to review all the documents within the timeline before the next status conference, but possibly within the timeline indicated by Your Honor. The fact, Your Honor, is that there are competing deadlines this month with the filing of the pretrial brief and the Rule 109 chart shortly after that. That's why I wouldn't want to commit to a 2 weeks timeline considering these other deadlines, but perhaps a 3 or 4 weeks deadline that would be absolutely workable, Your Honor.
So can we agree that you will try to do it in the next 2 weeks? It's reasonable to think that in the next 3 or 4 weeks it will be done, and the absolute maximum timeline is the next status conference.
Yes, Your Honor. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Let me turn to the defense. Mr. Gillissen.
Thank you, Your Honor. Your Honor, I have some submission concerning exculpatory material, but with respect, I prefer to address them together with the other elements when we come to the point E of your order related to the difficulties faced and foreseen in the disclosure process. I propose to make my submission in a more complete and comprehensive way at this moment, please.
Absolutely. And let me stress again that as long as the disclosure of exculpatory material is finished, the defense cannot efficiently prepare its case. So it's fundamental for the timeline of the case in general that this is done as fast as possible. Finally, let us now move to Rule 107 material. In its written submissions, the SPO indicated that it received clearance from the information providers for additional items subject to restrictions under Rule 107, partially in redacted form. However, the SPO still awaits Rule 107 clearance for a small number of items. So I would like the SPO to give more details on these materials, the anticipated timeline for obtaining clearance and completing disclosure, and the timeline of any request related to Rule 107 material. Mr. Prosecutor.
Yes, Your Honor. We have indeed added 7 documents to the Rule 1023 list for which we've recently received clearance. There remains maybe twice as many for which clearance remains outstanding with the document provider. Now, Your Honor, it's difficult to indicate timelines when it comes to discussions with the document providers because that it's a two-way discussion. So we may make a request, but then it needs to be answered. So at the moment, I'm not able to provide a specific timeline. I can say that there are just about maybe 10 to 15, and that we are in discussions with the documents providers, and we will seek leave to file a new updated Rule 1023 list when we get clearance to list these additional documents.
Thank you, Mr. Prosecutor. Mr. Gillissen on the Rule 107 material.
Thank you very much, Your Honor. We take notice. We do receive this famous notice. We need, of course, some time to read it, to analyze it, and we will be able, after that, to select some documents, and I suppose we will be able to provide some information for the next TTU conference about that. Thank you.
Thank you, Mr. Gillissen. Before I move to translation, let me ask the parties if they are facing difficulties related to the disclosure process in general. I think, Mr. Gillissen, you wanted to make some remarks on this, but before I turn to the defense, Mr. Prosecutor, would you like to make any general remarks on top of what you've already mentioned?
No, Your Honor. Thank you.
Thank you, Mr. Prosecutor. Mr. Gillissen, please, then.
Thank you very much. With respect, Mr. President, you have the point D about the rule 95 and 2.
Absolutely. So you can present submissions for both.
Okay, thank you very much. So we take note, and are waiting for the SPO. Your Honor, we start to discover and identify evidentiary materials that they are very likely to be the subject of admissibility challenge from the defense. But that being said, it is too soon to make any meaningful or firm indication in this regard. I believe that once we will receive a full and complete disclosure as well as a pretrial brief and chart from the SPO, we will be in position to analyze the totality of the SPO's case and start taking position about it. So the second issue is about Rule 102.3. As we know, this concerns a notice concerning the documents in possession of the SPO, and documents that the SPO don't have the intent to use during the trial. We received this SPO notice in due time, but very fastly we had to face some issue, and we discussed with the SPO to find some solution. We select almost 1,200, I think so, 1,196 documents, and on the basis of the table issued by the SPO, but we had some difficulties to understand what really are some of the documents, because description issued by the SPO was sometimes insufficient, I think so. So, by the way, we received some badges, and at the end of the process, we received a batch of 400 documents in which we discovered there were 96 items of exonerating material. And indeed, we discovered in a batch of disclosure, on the basis of Rule 103, those same 96 documents. So I consider we do have a real issue. I think it's more than an issue, it's a real problem, Mr. President. Indeed, it means that the duty and obligation of the SPO to review and disclose immediately all the disculpatory material in its possession has not been fulfilled properly. And we only received the 66 intents, 96, sorry, intents as exonerating material after we have selected them from the 102.3 notice. I use the word after our selection of document, but maybe, and it is a little bit terrible to say that, maybe the word because we select the intents from the Rule 102.3 notice. I'm sorry to say that, but the appearance could lead to such a conclusion. I don't want to make some conclusion, because it could be unfortunate appearance. But the fact is to focus on, and my conclusion is, in such condition and circumstances, may we have full confidence in the SPO treatment of the exonerating material according to his duty, which are, I don't have to remind you, you remember us, immediate disclosure and continuous review of the exonerating material. This is not an attack against the SPO. I want to really underline, this is not an attack. This is an alarming statement of fact. By the way, the SPO itself as you say, informed us in this filing of yesterday that they review only 30% of these documents. And so I have two other issues to raise again. The second issue concerns a related matter. It concerns the notice issued by the SPO. More precisely, we have a huge problem with the description I want to focus again on this problem of some items. Upon reading analysis of the disclosed material, we discovered that the quality of the description of many items are so poor that we are able, I'm afraid, to say it's insufficient or even inadequate. Inadequate to be able to understand the real content of some documents. Of course, I will provide you with 2 examples to illustrate. First example, I give you the ERM SETF 00375011-00375-014. The description of the document mentions a DVD and a date. But this is only after the review of the document selected that we realize this document relates to a witness in the case. When I talk about poor or insufficient or even inadequate description, we have, I'm afraid, a good example. This, of course, should be included in the description of the document in the notice. Nothing among the hundreds or thousands of documents described in the notice was able to alert us, and so we asked for it, anyhow, fortunately. But we could have missed it without knowing what we have missed. So I do have a question, a real one for every one of us. In such condition, how many interesting, relevant, or important, maybe exonerating material or intents did we miss? That's the question when we are busy to deal with things like this. So the second example, I consider this is a very important one, even if it is among many of others. ERN 091275-091387. The description of these items was a very simple reference number to certain proceeding without any other description. So we asked the SPO to improve the description. And we receive, because we are collaborating, of course, we receive a new description with very new detail that the document refers to a person of great interest. So we were really lucky to have asked for better description and to have selected the document, because the topic of this document was of huge importance and high relevance. This topic should, of course, be mentioned in the description, and to miss it would be extremely prejudicial to the defense. A third correlated matter lies in the fact that there are some missing relevant material which were not listed in the SPO notice. We can give you an example of this, a very simple one. We have received documents which make reference to one relevant intent, and this intent is not in the notice, despite the fact that this intent is evidently relevant for the defense. I don't want to be more precise, because we are in open session, and I don't think we have to pass or the necessity to pass to closed session. I just want to put it on the record, because we are discussing this intent amongst others with the SPO. All this to say, because it's time to conclude, all this to say, we cannot continue to hope to be lucky and select the right intents, and to hope not be relevant items or element necessary for the defense. So we would like to submit to you that the SPO should review his 1023 notice for completeness and proper and exhaustive description, and amend it and complete it as necessary for the effective and efficient exercise of our right to the disclosure of all material relevant to our defense. Especially since we are discovering as we go that items are missing from the notice and or improperly and insufficiently described. The risk for the defense, and in my opinion, for the procedure itself, of course, is to miss some important or relevant document and not to get access to them as a consequence of these shortcomings. So our conclusion include also the SPO notice remained and stay open for the defense. This means that there should be no deadline for the defense to select items from this notice. This conclusion is not a wish. This is really the result of our practice, of the practice we have entertained during the past several months. This conclusion is also the result of the reality of the proceedings, as you know, Your Honor, as you know, after we have completed all our selection in the notice. On the eve of our last statute conference, literally the night before, we received a disclosure concerning an extremely important document regarding the existence of an extremely interesting procedure concerning an extremely relevant person. This was at this moment, the deadline has already passed. So we have to avoid such a situation, and that's why the topic of those documents lately disclosed will continue to be highly relevant to the defense, and we already placed on the record of the proceedings that we make all legal reservations and we reserve our right to come back to this issue after we get full disclosure, as asked to the SPO, to all elements relevant to this topic. And I thank you to accept that things like this is in the record. I will say no more at this stage, Your Honor, on this issue, but simply to reiterate that the SPO should review its notice from completeness, proper and exhaustive description, and the notice should, in the interest of the integrity of the procedure itself, remain open for the defense, and this is the interest of everybody, I think so. This must be understood as a positive opportunity for all of us. We have a new prosecutor in the case. That's the occasion, really, and I'm sure that all together we are able to enforce and to make better the things, I think so. Mr. President, I don't have to be more complete. I think you understand perfectly well what I want to say. And if you have some question, I'm ready to answer. But I suppose we have the wish to avoid to enter in a closed session. Thank you very much.
Thank you, Mr. Jlissen. I perfectly understand the issues. I think you raised 2 points. The first of the Rule 102.3 material for exculpatory material. This is what I mentioned a couple of minutes ago when I discussed about the timeline. I think this is a question of timeline. This should be done urgently. I think it's already very late in the process for this, so this should be done urgently, and we already had the discussion with the prosecution that there is a commitment on the prosecution to do it in the next 2 weeks, if not in the next 3 to 4 weeks, and an absolute deadline for the next status conference. And then there is another issue that you explained in more detail, which is the details in the description of each individual item in the notice, which is something that has already been discussed in other cases as well. I will give the floor to the prosecution, but let me add another question to the prosecutor. Do you see the possibility to add more specifics to the notice following the examples that have been given by the defense, or do you consider that the notice is in itself clear and you see no reason to supplement it? I ask the question because I think that we at least need to have a clear view today if there is a disagreement between the parties on this. Because if there is a disagreement, they probably need to be litigation and a decision, because we cannot leave this for the end of the pretrial phase. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. Your Honor, we've already discussed the issue of 103 disclosure, so I won't rehash it. With regard to the descriptions in the 1023 list, we submitted updated descriptions in October, and to the extent that the defense finds some of them still unsatisfactory, we encourage them to point them out to us, and we will be happy to provide additional descriptions where the item in question so requires. But we oppose the filing of a new 1023 list because we do believe that many, in fact, if not the entirety of them, that generally the descriptions are satisfactory. Now, I do not take issue with what counsel said. There may be some outstanding items that are not sufficiently identified, and so I do encourage the defense to get in touch with us, and we will provide additional descriptions for these items, Your Honor.
Thank you, Mr. Prosecutor. So from what you just indicated, I take that you invite the defense to send the list of the items for which it requests more detail. Is this a solution that is satisfactory for the defense? And if not, what would the defense request? Mr. Ayuni.
Thank you, Your Honor. Just to say that this is the obligation of the SPO, not ours. We have done our part in our discussions. We continue. It's been very effective, and we already resolved half of the problem. We've sent requests for further description and better description for around 1,500 items, for which the description was totally useless. If you put some numbers and slashes and some numbers and some dates, we cannot know whether it's relevant for us or not. It's just as simple as that at some point. The real issue and why we're bringing it after literally the deadline for notice is closed for a few months, and we are in the reception of the items, that we still discover when we look at the content of the document that the description is not sufficient, even after updates. And this breaks the element of trust in the titles that we are looking at to be able to select. That's the real issue. And so it's really a combination. Since the SPO are reviewing their notice for exculpatory material or any kind of review and analysis of these items, if they can provide better descriptions, it will be helpful for the defense. The other part of it is if you leave the notice open, then we will have a chance, as we identify certain items, sometimes by the reference that is mentioned in the content of one document, and then we can go back to the notice and select everything that is with that same reference. This is the practice of what is happening. So if we say we're too late to select new items, while we discover only later that this reference number is relevant or that W number is relevant, then it is one of the two. Otherwise, we will not be able to effectively exercise the right to access what is relevant to us. We don't want it to be cumbersome, but we don't want to have litigation afterwards. We are looking like in few months where we would say this must have been better described for us to have it. We cannot have missed it, and we should not have missed this item because of lack of description or inadequacy of description. So this is what we are trying to resolve, to be honest. And maybe one slight point on the exculpatory material. Yes, there is the problem of timeline, but there is also, and we want to put it on the record, also the approach of what is exculpatory. We had multiple discussions with our colleagues. It's been very helpful on materiality, on what is exculpatory. And the example Mr. Gillissen made about a document we received making reference to another document. This was exculpatory material making reference to more general documents, for example. We believe that if that is a source or a linked document, that is at least relevant to us. So the approach that the SPO has to take is that the context has to be exculpatory and the general background that we need to understand related to one exculpatory information. We need to be in agreement with that, and that they take the more extensive approach possible to what is exculpatory. They are not going to decide what is our line of defense or what is relevant to us, or the persons of interest, or items of interest. So they have to take this open view with exculpatory and also with relevant and material items, because some of the items are not in the list and they should be there. And this is part of the reason why we engage in these discussions and really trying to get the position of each one to not misrepresent what is the position of the other party. This is a constructive approach that we are taking to not mislead any party, not to mislead the other, but at the same time come to the solutions where we get what we believe we are entitled to. So these are the points we wanted to make. Thank you, Your Honor.
Thank you, Mr. Yuni. Mr. Gillissen, you want to add something?
Yes, thank you very much, Your Honor. Just to add something, really. That's just an addition, but it's a very important one, I think. So I would like not to be obliged to select all the items of the notice. And I have the feeling that if things continue like that, I will be obliged to make it just to avoid to avoid such a situation. We don't have access to an important element or information. That's really the purpose of what I say. Thank you very much.
Just a follow-up question to the defense. Have you finalized the choice of documents in the notice? Because the deadlines that I set earlier were for November and December, if my memory is correct. So we are already beyond these deadlines. So are you requesting an extension? Or are you because now I think we have two debates at the same time. A debate on the timelines, because you tell me that you want more time, and a debate on how precise shall the list be. I understand that these two are interconnected, because if the list is not precise enough, you will tell me that you are not able to select the document correctly. But then they need a ruling for that, because if the deadline is already passed, you ought to do it before the expiration of the deadline. Mr. Berguni.
Thank you. I'll try to simplify things as much as possible. The deadlines have passed. We have made the selections. We requested additional descriptions, and we got them, and we made our best effort, and we even beat the deadline to make our indications in batches and before the last day. The problem is that we are realizing, as we look at the content, that descriptions, even with improvements, with the best efforts there, are still inadequate or insufficient. That's part one. Now we have a supplemental notice. And what our defense is requesting is that there should be a review for the completeness to look at what's missing from the items and be listed in the notice, and for better description since the review is ongoing, so that we receive another notice from which we can have a new opportunity based on a better analysis of what's been disclosed so far and the PTB and other things, that we make new selections. And that's the correlated part where Mr. Gillissen submits that there is no reason for us to have a deadline to select items, because what we know is relevant today might be complemented by what we analyze and know in 2 or 3 months. And we will be more precise and more aware of what could be relevant to us. And there are things that discover. And Mr. Gillissen made a very extremely important example about a new topic that we discovered after this deadline already finished for us to select items. And we were lucky, and we should not work on luck. We were lucky that we selected one item related to that topic, but now we need everything on that topic. What if some other documents are in the notice related to that topic? We need to explore and get access everything related to this topic. There shouldn't be a bar to the defense to select what's relevant to us, especially if we receive some documents after this notice is closed. So for us, it should be open, because the descriptions we cannot trust at 100%. We're all human. We can only do as much as we can. And there are things that come up in the course of the proceedings that make some element relevant, while we couldn't reasonably, with all the diligence and best effort, identify it as relevant before. Otherwise, the solution, which would be really unfortunate and would defeat everything we have tried constructively together with the SPO, is to select everything from the notice. We understand that there will be things. I mean, I'll give you an example. Mr. Shala has his last name as Mr. Shala. But Shala is also a region. So not everything that is in the list will be material to us. But we have to avoid selecting everything just to make sure. We have to come up with a better solution together so that we don't miss some important elements. So better description and open deadline, no deadline for selection. Thank you.
Thank you, Mr. Ayuni. Mr. Prosecutor.
Your Honor, as I said, I've listened attentively to the grievances that the defense has presented now, but our position remains that we have provided improved descriptions on the 25th of October, and we do believe that these descriptions are adequate. Now, to the extent, again, there may be some descriptions that are not, and we are prepared to provide better description for this. But we oppose a request to review again the entirety of the 1023 list to improve generally all the descriptions, because many of them, my position is the vast majority of them are more than sufficient to give notice of what the defense may expect to find in the document. Now, when it comes to possibly missing documents, again, I encourage the defense to get in touch with us, because there may be many reasons why a document is not listed, one of them being that perhaps we don't have that document in-house. So I don't know, I'm just speculating because I don't know what document the defense has found that is missing from the 1023 notice. But these are my answers to the defense submissions, Your Honor.
Thank you, Mr. Prosecutor. Do you want to add anything on the defense side?
Mr. President, my dear colleague, you understand what we are trying to seek is to avoid a catastrophe. I don't want to discover a document insufficiently explained in the notice in 2, 3, perhaps 6 months. That's only the purpose. It's not a question to win time or something like that. That's why I consider that if we want to avoid the possibility I ask all the documents on the list of the notice, we have to find a solution. And I think to let open this notice, in my opinion, is the best way for all of us. But you have to decide, Mr. President, of course.
The result of what you ask, Mr. Gillissen, is basically to suspend all the deadlines related to the communication, disclosure of evidentiary material for the Rule 1023 material. In practice, that's it. And basically that you continue inter partes discussions with no deadlines, asking them to supplement documents after documents. The problem with that solution is that it's endless. It can last 6 months, 8 months, 10 months. I cannot, as spiritual judge, leave this without any deadline. This is just not possible, because if I do that, you will not be able to continue your work, which is your investigations, because you will not have had the disclosure of all the exculpatory material. So I'm sympathetic to the fact that you are trying your best to find pragmatic solutions with the SPO, but at the same time, I find it very complicated to suspend all the deadlines for this category of material. So I think it's probably, I think there are two things here. For the updated Rule 1023 notice, the last one that has been filed, for the new items, of course, the previous deadline do not apply. But for the items that were already in the notice in October, there are some for which you have requested more information, i.e. either you get the document or you get more information in the description to decide if it's interesting or not. I think that's totally logical. But for the documents that you haven't requested, for the ones you haven't requested neither to supplement the description nor the document itself, is there an issue? Because this is where I'm not clear. Are you saying that, no, that's fine, our problem is only the documents for which we've requested more details? Or is it also these documents that you haven't requested, but that you are not sure because you don't have enough information? But for these, you had a deadline to request these documents. So if you didn't request inter partes to the SPO to supplement the description, you should have gone to me then to suspend the deadline or for an order to the SPO to do this. You see my point? You had a deadline for this, and it's perfectly within your rights to ask more detail to the SPO. But if you haven't asked anything for some documents, I don't see how I can reinstate previous deadlines. Mr. Ayuni.
I'm sorry, Your Honor. Maybe we've not been clear enough. I'll try to re-simplify. The documents for which we didn't request better descriptions, we didn't select. We gave the example of a reference to a procedure. After the notice has closed, and we have met this deadline, we requested descriptions and we selected everything before the deadline that Your Honor gave. The issue is that if we discover today a new topic, a new reference number, something new, and we find out that some of the items related to this issue or topic or person is in fact in the notice and we didn't select it, are we foreclosed from selecting a document that is relevant to us? That's the main issue. That's why we wanted to be open, because it's not just 15 more documents in the notice and then we can only select from those. Those can contain information on persons, locations, anything that makes other items relevant. And that's when we need to come back to the notice. Under your control, we're not trying to abuse. The whole process is not to abuse the notice process or to keep it open-ended. No. Maybe we can skip one deadline and go further to what the SPO announces as another notice that is coming, and then after that time we have a firm deadline for everything on the notice. But it's just to allow us to not miss something. And as the Englishmen say, you don't know what you don't know. Sometimes the descriptions, you don't know what you missed if you have missed it. And sometimes we discover from other sources that there is an information and it is related to one or two items in the notice. That's when we want a path to come back and request something that is relevant to us. It could be without the notice. We can make the request to the SPO, regardless of the notice, And we do that, actually, we are doing that. Like, give us everything you have on this topic, whether it's on the list or not, whether it's on the notice or not. That could be an agreeable solution as well. We understand your point that it can be endless, but at the same time, we have to be afforded a real opportunity to access everything that we need. Thank you.
Thank you, Mr. Irini. I think it's very useful because from what you indicate, you're not talking about all the items on the list. You're talking about if in the hypothesis you were made aware of a new fact, or notably through the disclosure of exculpatory material, you wouldn't be barred from the possibility to request a document that you couldn't know at the time would be material for the preparation of the defense. I get this. Mr. Prosecutor, do you want
Mr.
to...
President, just one thing.
Briefly,
one
Mr.
more thing.
Gilsen.
I think the topic is a difficult one, that's sure. I'm sure you understand and you show it, our point of view, and I understand perfectly your point of view. I think that we need, the parties need a decision of check and balance about this problem. Because when we say not to close, the possibility to go on the notice, it's too simple, you understand it now, you understood it perfectly well. But I think it could be very nice to have a decision, a very clear one, and for all of us, it's helpful in our relation. We have good, as you know, relation with the SPO, and I don't want to create a problem like this. I'm sure there is no intent in the SPO, in the way treating this information. It just could be a misunderstanding, but I don't want to...
Mr. Gilsen, I interrupt you for a second because I see that the connection with Mr. Shala has been interrupted. I've been told that the connection is being re-established. If you can just wait for when the connection is re-established to continue, so Mr. Shala doesn't miss any moment of the hearing. Sorry, Mr. Gilsen, but it's important that Mr. Shala can be attending the hearing. I see that the connection has been re-established. Mr. Gilsen, you can continue, and sorry for the interruption.
I understand absolutely the kind of difficulty with the technique. So I just was focused on the fact that we do have very professional contacts with the SPO. I would like to continue it like this. And there is, I told you when I said no attack, of course, there is no intent from or to the prosecutor. No, that's only the question, to be sure that the procedure is really a fair one for everybody. And I'm sure for everybody, if we discovered something like a document that we consider truly or falsely, but we consider as very important but too late, it's really, really a pity for all of us. Thank you.
Thank you, Mr. Gilsen. Mr. Prosecutor, do you want to add anything?
Just very briefly, that should that situation arise, a situation described by Mr. Rini of a document that could not have been discarded at the time, we invite them to get in touch with us. I'm sure the solution will be found. To the extent that it requires litigation before Your Honor, then I think at that point, sort of from prejudice should be shown in order for such requests to be granted. But we don't believe so far. There's been no need litigate this issue. So we remain extremely available to discuss any such instance with the defense.
Thank you, Mr. Prosecutor. I don't think we can solve this matter at this hearing today. However, I think it's important to address the concerns that the defense just presented. So I would invite the defense to file written submissions before me to basically present the difficulties you face for the disclosure. But I think it would be very useful if you could file these submissions when the SPO has finalized the disclosure of exculpatory material, because this can also help you to with the problems that you faced within identifying important document in the notice. As long as you haven't had the disclosure of the 102.1b and the 103, you're not in a position to be aware of all the criteria that you take into account to make your choice on the list. So I invite you to continue discussions inter partes, that the prosecution informs you of the disclosure of exculpatory material, and hopefully within 2 weeks or 3 or maybe 3.5, Mr. Prosecutor, I invite the defense to seize me at this time with an update on the disclosure and any potential request. But I think it's going to be more efficient if it's after the SPO has finalized its review of Rule 103 material. Unless there is... Mr. Prosecutor.
Your Honor, no, just one, I think, answer I owe you on the Rule 102.3 topic that we have discussed earlier. You had asked me whether we foresee future amendments of the Rule 102.3 notice, and I didn't answer you on that. We foresee that is possible if and when we obtain clearance for the new Rule 107 documents, but also, Your Honor, the SPO continues its investigations as part of its mandate, so there are new documents that are periodically acquired by the SPO. To the extent that these documents are relevant to this case, we may periodically need to update the Rule 102.3 list.
This is noted. Let us now move to the issue of translation of filings and evidentiary material. In its submissions, the SPO indicated that the parties continue to be engaged in discussions about the translation of evidentiary materials, and that the SPO does not intend to rely at trial. I know that the defense indicated in its submission that it has also made a request for translations and for prioritizing the translation of specific material. I would like to therefore hear the parties on any further issues regarding translation, starting with the defense first.
So, Mr. President, so far we didn't request any translation of evidentiary material from the registry. But we start contact with some element of the registry in this way. We will inform you of the next stage to conference about the progress made in this regard. What we can say, it is so far we have been able to rely on our internal resources in the matter. But with the reception of hundreds of documents from the notice, we will certainly seek the assistance of the registry language services. I have to add concerning the translation of filings, if you remember, that the registry provides us with draft translation of the filing request as they have announced it during the last session of the Statute Conference. We thank them for that, and we confirm it is very helpful for us. Your Honor, I would add that the translation of the prosecution pretrial brief in Albanian should be treated with high priority for the defense. I think so. I have to continue to the point B, Mr. President. Yeah. Since the last TQ conference, we have discussed with our colleague of the SPO, and during the recess, we have reviewed the document concerned for which we don't have any translation. We have prepared a small list of priority and submit it to the prosecutor. I'm sure we will continue the discussion in view of obtaining the translation of the most important one. So in the meantime, we request from the SPO the translation of some document of interest to us that we receive from our notice indication. We made the request on an ad hoc basis, and our colleagues from the SPO provide us with the translation in their possession, and we want to thank them for that. Thank you very much.
Thank you, Mr. Gillissen. Mr. Prosecutor.
Nothing, Your Honor. Thank you.
Thank you, Mr. Prosecutor. Mr. Nielsen, can you take note of the request of the defense to prioritize the translation of the SPO pretrial brief in Albanian?
Thank you, Your Honor. Yes, we'll take note of this request. Thank you.
Thank you, Mr. Nielsen. Let me now move to the third item in our agenda, which is the status of the SPO's investigations and next steps. Before discussing the matter further, I would like to ask the SPO whether it is necessary to go into private session.
Yes, Your Honor. To preserve the confidentiality of the investigation, that will be necessary.
Thank you, Mr. Prosecutor. Mr. Court Officer, can we move to private session?
We're in public session, Your Honours.
Thank you, Mr. Court-Officer. For the next point on the agenda, I'd like to turn to the defense first. I note from the defense written submissions that it is still unable to provide any information on the anticipated duration or status of its investigative activities. I also note that the defense is not at this stage able to confirm whether it will make any request concerning unique investigative opportunities and whether it will provide notice of an alibi or any other grounds excluding criminal responsibility. I invite the defense to provide any additional information, notably a timeline for their investigations, or to indicate when it anticipates to be able to do so. Mr. Gillissen.
Thank you, Your Honor. We are happy to report that we continue to advance in our investigation, but we have to face some issue, and the very first one, as you are able to imagine, is the COVID-19. And so some members of our team were victims of the disease, themselves or their relative. Unfortunately, one member of our team even lost a very close relative recently. We extend one more time to her our condolences. And the impact of the situation in the ground affects our ability to work, to meet, to travel in the manner that we envisaged before the recess. So that's really a huge problem. That being said, we still could make some progress on different facets. We have already identified the main and principal objective of our first mission on the ground, and we are planning on the basis of the informations we receive from the ground, a first travel for our first mission on the end of February or the beginning of March, depending, of course, of the sanity condition on the ground. We made an important preparatory work in that respect, and we will continue to do in the next several weeks. We also are engaging actively in contact with some experts who could assist our case. We shall say no more at this stage, but we will provide you with updates as necessary, perhaps, in the next conferences. Thank you very much.
Thank you, Mr. Gillissen. Mr. Prosecutor, do you want to respond?
No, Your Honor, thank you.
Thank you, Mr. Prosecutor. I invite the defense to continue its effort. I know it's complicated with the pandemic situation. Nevertheless, it is important that you can proceed with your investigations as soon as possible. Let me move to the next item in our agenda today, which is the points of agreement on matters of law and fact. In this regard, I note that the parties have conducted their discussions regarding potential points of agreement on law and on facts. The SPO indicated in its submissions that it expects to be in a position to identify certain of these issues by the filing of the SPO's pretrial brief. However, I note from the defense submission that no progress can be reported on the parties' discussions related to the possibility of submitting points of agreement or agreement on law and or facts. So can the party again give an update on this topic and especially on when they will be in a position to make submissions on this matter? Mr. Prosecutor.
Your Honor, we plan to start working on a set of facts to propose to the defense for agreement further to the filing of the pretrial brief. And I think that will get the ball rolling, and once the defense, I understand they also will be waiting for us to make the first move in that regard.
Thank you, Mr. Prosecutor. Mr. Gillissen.
Thank you very much. I have nothing to add, just it will be a pleasure to discuss about all of these topics. Thank you very much.
So I invite the SPO to get the ball rolling as soon as possible after the pretrial brief then. I would now like to ask the registry to give an update on the COVID-19 situation and the mitigation measures in the detention center. In particular, if the regime has changed since the registry's fifth update on such measures. Mr. Nielsen, please.
Thank you, Your Honor. So the latest formal update was on 1st December, so indeed I have a short update for you today. As you are aware, temporary measures restricting visits were applied at the end of November at the detention facilities. Based on the medical officer's advice, in-person visits with family members and counsel resumed at the facilities on 7 December. Now, in light of the very serious COVID-19 situations in the Netherlands and elsewhere, of course, the medical officer has advised that we take a very cautionary approach to lifting the other temporary restrictions for the moment. So the other restrictions remain in place, and they will remain in place until at least 17 January, so that's next week, when there will be a review of these measures. So that is essentially where we are. The detainees are all aware and have been informed about the different at the different stages of the measures. The registrar is continuously monitoring the situation and engaging with the medical officer to facilitate the full lifting when that is possible from safety and health perspective. And of course, we'll commit, as always, to keep Your Honor informed about future developments. Thank you.
Thank you, Mr. Nielsen. Does the defense want to react to this update, Mr. Gillissen?
No, thank you very much. It was very complete. Yes, thank you very much.
Thank you, Mr. Gillissen. At this point, I would like to ask the parties if they have other issues they would like to raise. Mr. Prosecutor.
Thank you, Your Honor. Nothing further from the SPO.
Thank you, Mr. Prosecutor. Mr. Gillissen?
It will be me,
Mr.
Your
Ayuni,
Honor. Yes.
Sorry.
Just to put on the record one discrete item in anticipation of the pretrial brief. After the first States Conference, or maybe between the first and second States Conference, we spoke with our colleagues from the SPO, and we made the request that within legal workflow, the witness entities be created. This is something that has been very, very helpful in previous experiences in tribunals using the legal workflow. We had discussions with our colleagues from the SPO about it, and they agreed to do it. And at that point of time, they indicated to us that this could only be implemented at a later point, which is after the issuance of the PTB pretrial brief and the chart. So just to put it on the record that we are in agreement for a long time about it, we believe this will help us immensely to identify, confirm, or review the links that we have established from what was disclosed to us before, and probably will help us further with the analysis and understanding of what's in the notice, what's disclosed, what's exonerating. So just wanted to put it on the record. Thank you, Your Honor.
Thank you, Mr. Ayuni. Mr. Prosecutor, can you confirm your willingness to create these witness entities? And I also take the opportunity of this discussion to ask you to confirm that you will be filing the pretrial brief and the Rule 109C charts as planned, Mr. Prosecutor.
Your Honor, we must certainly confirm our availability to provide, to release the witness entities, and we do confirm that we will be filing the pretrial brief and the Rule 109 chart by the deadlines set by Your Honor.
Thank you, Mr. Prosecutor. This is noted. I would like to ask the parties now on for their views on the date for the next status conference. The date that is foreseen is Friday, 4 March 2022 at 14:30. I repeat, Friday, 4th of March 2022 at 14:30. Would this be convenient for the parties? Mr. Prosecutor.
Yes, Your Honor. Thank you.
Thank you, Mr. Prosecutor. Mr. Gillissen.
I really have the wish to say yes, but it's a little bit difficult because we we have the hope to be on the ground at this moment. So it's not a reluctant yes, it's perhaps one. Mr. President, I will try to manage to be ready for this date because I know all the problem, of course, of the courtroom and so on. Okay, thank you.
Can we agree that you will get back to me within, I don't know, 2 weeks to confirm me the date of your mission? I mean, that's entirely up to you, but your availability or not for the 4th of March. I mean, if it's the only option for you to go on the field for investigations, that's the priority. Don't delay this. We'll find another moment. I don't want you to delay your investigations for this, but it would be useful to have this information as soon as possible because, as you know, the courtroom is pretty busy these days, so it would be useful so that we can find a time frame.
Sure, for sure. Maximum 2 weeks. I hope to be able to provide you the information in 1 week maximum. Okay, thank you.
Thank you, Mr. Jelissen. This is much appreciated. You will receive a scheduling order that will include the agenda before the next status conference after we have agreed on the date. I invite also the parties to make written submissions if they would like to raise any specific issues during the next status conference. This concludes today's hearing. I thank the parties and the registry for their attendance. And as usual, I thank the interpreters, stenographer, audiovisual technicians, and security personnel for their assistance. And I see that it's 16:01, so I've been 1 minute too late for the interpreters, but I hope they will forgive me. The hearing is adjourned.
All right.